A check is a very important document in business circles. It is called Negotiable Instrument Act, and I have seen so many people, gullible women, where their husbands are doing business, they sign the checks, and ultimately when checks are bounced for insufficient funds, they have gone to jails. So, all women, all ladies and all lady directors who hold the position in companies, please mind it that you do not issue any check without there being sufficient balance in your bank or account maintained by XYZ company. If you give any check and there is no sufficient balance, and once the check is bounced, it is an offence, and no matter after check is bounced you deposit the amount into bank, you cannot absolve yourself from the crime. Therefore, the crime is giving a check, issuing a check without maintaining sufficient balance in the account. So, once the check is bounced, what is the procedure adopted by courts? We will have to see. It is a check bounce case is completely a programmatic issue. First of all, the lawyer has to give a notice to the check giver, directing him, demanding him to make good the check amount. A time is given for 15 days, and within 15 days a notice is given first with a gap of 15 days, and this person who has bounced the check will receive the notice. After receiving the notice, he has to make payment to the person within 15 days, that payment. Suppose he could not make payment within 15 days, then the person who possessed the check has to wait for 30 days, and from the 31st date to 45th date, 15 days time is there for him, and he has to approach the concerned magistrate, concerned court of magistrate, and file a complaint under 200 CRPC for the offence of section 138 of a Negotiable Instrument Act. In such case, the court will take cognizance of that complaint and will allot calendar case number to it. Notices are sent to the check bouncer, and the procedure of trial as contemplated in Criminal Procedure Code will run as usual in case of any other offences. In check bounce cases, the danger is section 139 says that once your check is in the hands of some XYZ, and that XYZ has got an endorsement collected from bank which says that the check is bounced due to insufficient funds, then offence is committed. There is a presumption that a legally dischargeable debt existed between you and the check possessor, and once that phenomena established, then you are liable to straight away jail of 2 years term. Therefore, this danger is there. No matter whatever grounds you take urge, you may say your check is been stolen while you have kept that in your drawer, or you have signed a blank check and somebody has stolen it, or you have signed the check at the point of threat. Whatever defense you take, the defense is called alibi in Criminal Procedure Code, but in all cases 99% scope is in favor of the check possessor. The check means bounced check, and once that possessor of the check approaches court, he will get judgment in his favor. That means conviction is 100%, 99%. Why 1% I am not saying is, one is that you may lodge a criminal case against the person who possessed the check, saying that he has collected the check at threat point. Burden is on you to prove that you have been subjected to threat, and in the court of law, that is magistrate court before whom this check bounce case proceedings are going on, you have to file the evidence of your FIR, charge sheet, and you have to show the conviction judgment. Conviction judgment means the person who threatened you and collected the check will have to get conviction from the court. And if you file that conviction judgment before the court where check bounce proceedings are going on, then you may be absolved from that crime of issuing check without maintaining sufficient balance. Or else, first of all, you have to go to the jail and then you have to adjudicate your separate case for threatening or extortion, and later on you may get a judgment in your favor, and that judgment may be in your favor, proving the facts of your being subjected to threatening by the check possessor. But by that time you will be completing your term of 2 years. In such case, you may be at liberty of claiming only civil damages of any amount. These check bounce cases are these days creating lots of problems for women, because husbands are doing business in the names of their wives. Husbands may be government servants, so they do business in the names of their wives. So they ask their wives to sign the checks. These wives, without knowing the consequences of law, they simply sign the checks in advance, and these husbands are retaining the checkbooks signed by these wives. And once the check is bounced, the wife who has signed the check will have to face the consequences. Therefore, all women folk, ladies, be very careful in issuing checks. Please do not give a single check without maintaining sufficient balance in the account from which you have got a check. Therefore, the directors, similarly lady directors are there, because the Companies Act says that for a private limited company there must be minimum 2 directors. So husband will be one director and his wife will be other director, or his relative will be another director. If the relative happen to be a lady, she has to invariably know the law of Negotiable Instruments Act 1881, or else simply signing a check, she may be landing in a jail for issuing a check without there being a sufficient balance. That is why these check bounce cases, in almost all cases, section 139 says presumption. Once your check is in the hands of other person, it is presumed that there existed a legally dischargeable debt. There is no other go. Once you issue a check and check is bounced, there are only 2 options: either you go to jail or you pay the amount within the period mentioned in the legal notice. Now, of course, as the check bounce cases are coming more and more, now Supreme Court has been delivering some judgments where it is said that if the check is issued as a security and not as an instrument in discharge of a legal debt, then court said that conviction cannot be there, because there existed no legal liability, but your check has been given only as a security. In such case, you may come out of the crime, but burden lies on you to prove that the check was given only as a security and not otherwise. Recently, we have seen a case just about 4 days back. A businessman was confined illegally in a marriage function hall, and at the instance of very senior IPS officers, some private respondents have collected checks. There is no balance in the bank account, but this businessman signed the checks. His wife also signed as a second account holder. So the checks were issued to the tune of 1,70 lakhs. There is no pie in the bank account. What would happen to this businessman in future? A case has been registered for extortion against these police officers and also private respondents. But whether this complaint would come to help of this businessman means, I say right now no, because the check bounce case will be completed in maximum 6 months time, because special courts have been constituted, special magistrate courts we find in Era Manzil, about 25 to 30 courts. A check bounce case is being completed, adjudicated within a period of maximum 6 months. But a regular criminal case, that is to say the businessman's complaint of extortion by police officers, that would take at least 6 years to be decided by the criminal courts. By that time you will get conviction. This is the problem with the check bounce cases. So please do not issue any single check without maintaining a sufficient balance, and once you issue, please make sure that the check is honored at least within the 15 days from the date of this legal notice that you receive. There is no use avoiding the legal notice. You have to receive the legal notice. If you do not receive the legal notice, a presumption will be in favor of the complainant. So many cases, so many problems with the check bounce cases. That's all.